Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who regularly geek out on the channel, one, thank you. And two, you may recall this video we did last week, which was about the case of Barnett v. Raoul. But what it was really about was the Illinois Sheriff's Association weighing in on their petition for certiorari and filing an amicus in favor of the petitioner and against the Illinois Attorney General. Totally awesome. Well, today we're going to talk about another case that comes out of Illinois relating to their assault weapon ban and magazine ban. And as we know, there is all sorts of cases kicking around in Illinois. We've had an opportunity to cover all of them, and there's a lot more action left to go. But once again, law enforcement is weighing in, this time in the matter of Harrell v. Raoul. And I got to tell you, they've made some really, really good points. It's a much larger law enforcement agency weighing in. And this is a really, really positive trend that we need to continue to talk about. So today, let's go through the memorandum and let's talk about when the nation's sheriffs start calling BS on civilian disarmament. Okay, today we are talking about one of the many, many assault weapon ban and magazine ban cases coming out of the state of Illinois, any one of which could end up before the United States Supreme Court. Today we're going to be talking about Harrell v. Raoul, one of the cases, again, sitting right now with a petition for certiorari to the United States Supreme Court after horrific rulings on the 7th Circuit, which upheld horrific laws out of the state of Illinois, which were shoved down their citizens' throat in a horrific fashion. Now, before we get too far down, I want to thank our good friend Rob Beavis for tipping me off about this. He sent me this memorandum. I was able to geek out on it. So, Rob, good for you. And for those of you who don't know who Rob Beavis is, shame on you. He is the named plaintiff in Beavis v. Naperville, yet another one of the challenges to all of the shenanigans going on in the state of Illinois. And in many ways, Rob got it worse than everyone else because he got it first. Okay, now, what I was talking about today is that the National Police Association, sounds pretty awesome, doesn't it, has filed an amicus brief in support of Harrell's petition for certiorari and review by the United States Supreme Court. Many of you may have not heard of this organization. I had only heard of them a little bit. So who exactly is the National Police Association? The National Police Association, NPA, is a nonprofit corporation organized under Indiana law. The NPA pursues a general mission of advancing law enforcement interest, including participating in cases as amicus curiae when the case raises legal questions important to law enforcement interests. As a national association representing police officers across the country, the NPA is deeply committed to the maintenance of law and order. And again, I love the angle that these law enforcement agencies are able to take on this issue. And what you're going to see here is not only do they take a very aggressive angle, an angle that's based in reality and based in common sense and in their experience, but they really also are going to take the Supreme Court to task here. What exactly is the interest of this organization? Well, very similar to the Illinois Sheriff's Association. They state the following. This interest is becoming more acute as political forces have arisen driving policy choices that undermine the most fundamental duties of government to preserve order. Such policies have profound and primary effects upon the safety and well-being of citizens and police across the country, and secondary effects upon the Second Amendment as it is made into a scapegoat for the failure of these policies. Oh, yes, indeed. And listen, the NPA is not done criticizing some of these policies because, as they point out, the NPA sees the Illinois law here challenged as yet another manifestation of scapegoating for Illinois' policies favoring disorder and criminals. The NPA appears as amicus to provide the court with a law enforcement perspective on the critical questions of federal law and law and order generally presented by the petition. Now, one of the arguments that many people make in the 2A community, and it's true, is that the only way to stop a bad guy with a gun is a good guy with a gun. And now that, of course, we've gone out and de-policed our communities, those good guys with the guns more often have to be people like you rather than law enforcement. Well, the NPA was wise to this, and they pointed out, the NPA seeks to ensure that legally armed citizens remain available to supplement the nation's law enforcement in upholding public order. The NPA believes that the only thing that stops an evildoer with a gun intending on doing violence to others is a good man or woman with a gun and the will to use it and that cannot always be a police officer. The NPA believes that new laws outlawing weapons commonly possessed by law-abiding Americans will not only be ignored by criminals, but will also tend to promote crime. Now, I love where the NPA goes with this because, as you know, we have had an all-out war on our Second Amendment rights in the last few years. What else has gone on is there's been an all-out war against law enforcement. There's been a massive defunding movement all across the country. We all know the results of that movement, and so does the NPA, because they point out, as police departments across the country face funding cuts that seriously limit the number of officers on patrol, the role of armed citizens in preventing public disorder becomes more and more important. The cost and scale of anti-Second Amendment litigation is itself becoming inimical to the interest of the NPA and those that it represents, as scarce public resources to protect ordinary Americans are diverted to pay lawyers and experts clogging the courts that could otherwise be adjudicating criminal cases. Now, I've said on almost every video that I've ever talked about when speaking of law enforcement is that they have two roles, and they take both of them equally seriously. Number one, the obvious one, is they are there to police the community and make the community safer. They take that role very, very seriously. A second one, however, is they are to ensure that your constitutional rights are actually protected. And the NPA here expressly talks about that issue. A final important interest of the NPA is protecting the many policemen and women charged with enforcing the Illinois laws and similar laws from civil liability. The obviously unconstitutional nature of the Illinois restrictions has caused many law enforcement officers to state they will not enforce the law, in this case resulting in a threat from the Illinois governor to fire them. And if they do enforce the law, they are liable to civil suits from the law-abiding citizens that they are turning into felons insofar as no qualified immunity would be available for a violation of a clearly established constitutional right, which a reasonable person would have known. And then the NPA does a very good job of saying to the Supreme Court, hey, listen, there is an all-out attack, not only on the Second Amendment, there is an all-out attack on the authority and the legitimacy of the Supreme Court itself. What are you going to do about it? And then, of course, the NPA goes through all the legal framework in their argument, and it's really quite similar to all the other legal framework and other arguments that we've seen, okay? They're very critical of the Seventh Circuit, making up new rules out of thin air, coming up with more proper for military use and things such as that. But ultimately, after following all the very clear case law, and the case law is really clear here, the NPA comes to this conclusion. In short, the constitutionality of the Illinois statute is not a close constitutional question. The positions taken by the Seventh Circuit are not objectively reasonable positions that can be advanced in good faith by anyone respecting the Second Amendment. Now, there is a real criticism, and it's a legitimate criticism, that when we see all these liberal gun grabbers, and we see all the people in Hollywood who want to tell us how to live their lives, they're often surrounded by armed bodyguards themselves, while they're telling all of you that you shouldn't have guns to protect yourself. Well, this wasn't lost on the NPA either. Unlike the ordinary citizens, for whom the Second Amendment rights are frequently a life and death matter, the Second Amendment's opponents do not carry weapons to protect themselves and may even be protected by bodyguards. They live in a world so different from the world of criminality suffered by ordinary police and law-abiding citizens that they cannot begin to conceive the importance of the Second Amendment for its central purpose of self-defense, much less its importance as a doomsday provision designed for those exceptionally rare circumstances where all other rights have failed. Bravo. I think that is absolutely one of the best statements I've seen in any of these memorandums. Now, ultimately, they finish this up by challenging the Supreme Court and saying, hey, they're thumbing their nose at you. What are you going to do about it? Not only is the Second Amendment under attack, but the legitimacy and the authority of the nation's highest court is also equally under attack, as they put it. It is now clear that such disrespect extends to a host of federal appellate and trial courts besides the Seventh Circuit in open defiance of Heller and Bruin. All these courts are frankly engaged in what may be called legal insurrection against the Second Amendment. How good is that? Legal insurrection. Now, listen, this is an absolutely well-written brief. We're going to link it up down below so you guys can geek out on it. But they really kind of, I think, finish very strong, too, with yet another challenge to the Supreme Court. Unless this court puts an end to the wave of frivolous attacks on the Second Amendment, these gross wastes of public funding will continue to occur, fostering local disorder and continuing disrespect for the rule of law. The job of the nation's police officers will only get more difficult. They do not need more gun laws. They need the resources to enforce the laws we have that focus on criminal behavior involving guns and the simple willingness to uphold those laws by punishing criminals who violate them. So bravo to the National Police Association. This now makes the second Illinois case in which a significant, large law enforcement agency is weighing in on behalf of and in favor of the petitioner. The case, once again, is Harrell v. Raul. We'll link this memorandum up below so that you can geek out on it for yourself. Kudos to the National Police Association for all you do. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box as well. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.